Are you concerned that you or someone else has breached a contract? In this video, we'll discuss the different kinds of breaches that exist and the applicable remedies, also known as solutions, for each of those breaches. So what is a breach of contract? A breach of contract is when one of the parties to a contract does not do what they were supposed to do. When a contract is breached, the innocent party, which is the party that has suffered from that breach, it will be entitled to a remedy. More on remedies later. Before entering into a contract, we always advise our clients to read it carefully and make sure that their obligations are very clear and narrow in scope. This avoids them willingly or unwillingly breaching that contract. UK law recognizes three main kinds of breaches of contract: a minor breach, a material breach, and an anticipated breach. A minor breach is a small breach of the contract that, despite the fact that it has occurred, it still allows for the contract to be fulfilled. A minor breach is, for example, when a service provider delivers their services maybe a few days late, but the customer is not hugely affected and time was not really important. Then there is a material breach, and a material breach is a breach of the contract that goes to the root of the contract. An example of a material breach is when a service provider has agreed to do something but does not do it at all. An anticipated breach, instead, is a breach that hasn't yet occurred, but one of the parties believes that it will occur in the future. An example of an anticipated breach is when a customer may come to you, tell you that they've received your invoices, but due to cash flow reasons, they cannot yet pay. We always advise our clients to first understand what kind of breach has occurred, because this will determine what kind of remedy or solution they may be entitled to. I'm Zoppi, a qualified solicitor and the managing director of GZ Legal, a boutique corporate and commercial law firm that specializes in commercial contracts and corporate law work. For these kinds of matters, we offer our clients a contract review service. This is where we will review the contract, analyze the dispute, and determine how strong of a case our client or the other side may have. If this sounds of interest to you, visit our website now. For the last part of this video, we'll discuss the remedies that arise from a breach of a contract. For a minor breach, such as the service provider being late just a few days, you might want to send them a legal notice requesting that they fix or rectify this breach. If your notice is not complied with within a reasonable amount of time, then this may become a material breach of the contract. For a material breach, such as the service provider not doing what they agreed to do, you might be entitled to damages. Damages include loss of profits, loss of time, and the cost of remedy of that issue. For anticipated breaches, you might not be automatically entitled to damages. In any case, it is always best to avoid the courts. So, if you anticipate or believe that in the future a breach of a contract will occur, we would advise our clients to contact the other side, notify them of this possibility, and working out a way to resolve an issue before it even arises. Know that if you intend on claiming damages via the courts, then the courts will expect you to have taken proactive measures to mitigate your losses. Mitigating losses means to take actions that reduce the amount of losses that you will or have incurred. Thanks for watching, and make sure to check out the rest of the channel, which covers a range of legal issues that are relevant for small businesses in the UK. If you're interested in a free legal advice call, visit our website linked below now.